Welcome to A Taste of Justice. I am Professor Angela Mae Kupenda. This semester, I'm posting on my First Amendment course. My goal here is to give a little something extra to my students that I'm teaching remotely, but also for all of us, so that we may go further in achieving the goals of our Constitution. The Preamble says, we the people, in order to establish justice. So learning is key, especially learning about our Constitution. Now, this video today is just a little extra to cover a few concepts that will be very relevant in the coming week when we talk about defamation and obscenity. So I want to quickly cover just a few concepts that may be important, that are important for you to think about as we prepare to cover those topics, those categories of unprotected speech. So let's get right to it. Before we do, two things. First, I want to point out that the First Amendment is short, but there are many, many court cases interpreting our Constitution. All explanations here are my own and are not to be ascribed to my school or to my students. For informational purposes, I'm a professor at Mississippi College School of Law, and I've been a teacher at various colleges and universities for about 30 years now. The other thing I want to point out is back to our general rules. So generally, pure speech is protected under the Constitution. Pure conduct is not. Secondly, generally, pure speech is protected from content regulation by the government, unless the government satisfies a very high level of review, or unless the speech fits in an unprotected category. Some speech, the court has held that it is of such low value that government is allowed to regulate it more and under a low level called rational basis. In the earlier clips under First Amendment, we talked about speech that advocates illegal action and how the court has placed it in an unprotected category. However, through the years, how the court has described it to determine if a given speaker's message falls in that unprotected category has varied over time. Now, before we move on to the topics of defamation and obscenity, I want to just focus on a few concepts today that you will hear more about, and for my students, you will see in your reading that you're doing for next week, okay? So the first concept that I want to talk about is to help you distinguish between whether a law is valid on its face or valid as applied. Is a law, a governmental law, a rule, a regulation, or ordinance, is it valid on its face? Can you look at the language and determine it is, is it invalid on its face? Or is it invalid as applied to a given speaker? Okay, so if a law let me go back. Most of the cases we talked about with speech that advocates illegal action, we had a law, we had a rule, and then for a given speaker, the court was determining whether that speaker violated the rule, right? and whether that rule was legitimate under the First Amendment as applied to that speaker. In other words, the court was determining if the law was valid as applied to that particular speaker or that particular defendant. Valid, was the law valid as applied? But sometimes the court determines that a law is invalid on its face, that the language in the law itself makes it invalid under the First Amendment or under some other constitutional provision. So let me give you an example. Well, really what relates to our next term is the law vague. Okay, so what does the word vague mean? For something to be vague means it is unclear. And we want a law to be clear. We don't want it vague. We want the law to be clear so that we can order ourselves according to the law and know what is allowed for us to do without punishment and what is not allowed. So let me give you an example, a simple little example. Let's say that there was a law and the government was going to punish any person for speech that makes anyone upset. The government is going to punish anyone for speech that makes anyone upset. Now, what does that mean? What does make anyone upset mean? That language is unclear, right? That language is vague. And so therefore that language may lead to the law being invalid on its face, okay? Now let's look at another aspect of that same law. Sometimes a law may be broad. A law may be too broad. Let me say I've listed all of these concepts in the bottom in the text so you can look at them, you can Google about them and learn more about them. But you will hear us repeating them as the course progresses. So again, let's go back to the law I pitched to you. The law says that a person can be punished for speech that makes anyone upset. Now, that language is problematic. Something that makes anyone upset, it may be applicable to speech that advocates illegal action that has been determined to be unprotected speech, but it may also be applicable to speech that clearly should be protected. Look, I've been a teacher now for over 30 years. And sometimes, well, almost 30, sometimes when I tell students things that are historically documented, that are true, it may still make them upset. It may make them upset to think about it. It may make them upset because it challenges what they have believed for most of their lives. So a law that says that you can be punished for speech that makes anyone upset is too broad, right? It is overbroad. It is substantially overbroad because it covers both speech that is unprotected and it covers speech that is protected. If a law is substantially overbroad, then that law cannot be applied to anyone that law then may be determined to be invalid on its face. So even someone who's done something clearly wrong and unprotected with unprotected speech, if the law is invalid on its face, facially invalid, because it is substantially overbroad, then the law cannot be applied to them and no one can be punished under the law. So we're going to talk about instances where the court said, well, the statute is valid on its face, or a situation where the court says that as applied to this person, it is invalid, or it is invalid on its face. I know, it's weird, isn't it? It keeps getting more and more interesting, doesn't it? Now, if a law is substantially overbroad, then the whole law may be declared illegal, unconstitutional. But what if the law is only slightly overbroad? If the law is only slightly overbroad, the court may say, it is a bit overbroad, but we can narrow it. It can be subjected to what's called a narrowing construction so that that particular defendant can be held responsible under the law. We see these concepts a lot when we get to the material related to obscenity and whether a law is valid on its face or is descriptive enough not to be vague or not to be substantially overbroad. We'll talk about that more next week. Okay, let's go to our next concept, and I have my notes just to keep me on target. The next one is the concept of state action. State action. And for those of you who were in con law or who watched the con law videos, you know what I mean by this concept of state action. In some contexts, it's very similar to another concept I posted about called acting under color of law. Now, for full discussion of this concept, in my text box below this video, I've indicated the ones you could go back and watch. For here, I'm just going to briefly summarize a few points. Now, the Constitution essentially restricts government. The Bill of Rights, which include the First Amendment, was designed to restrict government action. So let's say I invite someone over to my house to give a talk. Let's say it's a political candidate. I invite the political candidate in my home to give a talk. And then you hear about it and you said, I'm running for office too. I'm running against that person you invited over. I want to come to your house to give a talk too. And I say, I don't want you to come. And you say, you just violated my First Amendment rights. Now, did I? Remember, state action is required. If I'm a private person inviting individuals over, then that is not the government. So even though I may not be hearing both perspectives, where is the state action if I am a private individual? So the First Amendment is a right that is asserted against the government, asserted against government action. And that is the concept of state action. Now, sometimes the government is right there in terms of a public school, the state police, what have you. But sometimes the government's involvement may be more subtle, right? The government's involvement may be entwined with the private involvement. That's why you need to go back and look at the earlier clips so you would see how that works. Now, in some of the cases we talked about regarding speech, we had the government saying, hey, we need to recruit individuals to fight in this war to defend the country. And your speech at the recruiting center is hindering our effort. And so therefore, we're going to arrest you. And so we saw that happen in some of the cases where the speaker was being arrested by the government. And so then that was government action. And the speaker said, you can't arrest me. I was just expressing my First Amendment rights. And from the cases we looked at before, you saw what were the outcomes in some of those cases. But I want to give you a slightly different situation based on what we will be talking about next week with defamation. Let's say the state said, we want to, let's say the state of Alabama, we want to have law and order and peaceful relationships. And sometimes people get mad when other folks defame them or tell a lie about them that damages their reputation. So the state creates a state law that says that if you make a statement about a person that damages their reputation, if it is not 100% accurate, then you can be sued for monetary damages. And let's say a person does so. So here we have this state law that's giving the process, is giving the avenue to sue individuals for their speech about other people. Do we have state action there? And in the cases that we'll talk about next week, you will see that the court did address the First Amendment rights of the speakers, and you'll see how all of that comes out. Those cases are something else. We just can't wait, but we will wait until next week, okay? So we had invalid on its face or as applied. We've talked about vagueness. We've talked about overbreadth, the overbreadth doctrine, and we've talked briefly about state action, telling you where you can go to learn more, okay? Let's go on to another point. So this point is called Selective Incorporation. I may have mentioned it briefly in an earlier clip. If you look at the text of the First Amendment, and I hope you've read it by now, read it a couple of times, it says Congress shall make no law. Congress shall make no law abridging free expression. And I'm paraphrasing. It says Congress, but the First Amendment applies to the federal government according to the courts. So what if, and let me go back, it says Congress shall make no law, but we know the court has already said no law does not mean no law. Some laws that abridge speech, some laws are constitutional, are valid, but that's the whole thing this course is about. So going back, Congress shall make no law abridging the freedom of speech, Congress. But the First Amendment applies to the whole federal government. What if a state, excuse me one second. What if a state makes a law abridging, and you say the state has abridged my speech rights? Can you assert the First Amendment against the state? We had several examples of this. One example was in the Brandenburg versus Ohio case. The state of Ohio had a law, and it sought to punish several KKK speakers under that law. Now, can you assert your First Amendment rights against a state or a city, a municipality, a county? And the answer is yes. But it's a little technical step. The First Amendment does not apply directly to the states or their subdivisions. The First Amendment applies directly to the federal government. But the court, through a process called Selective Incorporation, is really deep. The court says that, oh no, the First Amendment also applies to states. We have this thing called the 14th Amendment Due Process Clause. And the court has said that for a state to deny you your First Amendment rights is a denial of due process. So if the state is the one that you are asserting your rights against, you say my rights have been violated under the First and the 14th. If it's the federal government, you say my rights have been violated under the First. Just a minor point, but a point that may show up like in those bar exam questions that some of my many of our students will be taking the bar exam to become attorneys at law. Okay, let's go on to, well, I guess maybe one more point. Okay, now this is a word, and sometimes when I use it in class, students think I'm trying to be old school cool or something. They don't know it's a term that actually shows up a lot in First Amendment law. But has your speech been chilled? C-H-I-L-L, chilled. The court says we don't want to unnecessarily chill speech. So to chill speech means to somewhat silence the speakers so that they are hesitant or afraid to engage in, as Justice Holmes has said, the marketplace of ideas. Do you remember that from the Abrams case? Yeah, go back and review. Okay, now, I'm gonna, in describing this concept of chilling speech, I want to do a little introduction to our next video that I'll post next week, which will be on defamation. Now, let me ask you, when you were a child, did you recite the rhyme, "Sticks and stones may break my bones, but your words would never hurt me"? So is that rhyme accurate? Well, we know sticks and stones may break bones, but do words hurt? Has anyone ever said something untrue about you and it hurt you? Did it hurt your feelings? Did it hurt you economically? Did it hurt an opportunity for you because they told a lie on you? And similarly, I want to ask you this question. Have you ever lied on anyone else? Now, or anything else? What if I said that until next week, I don't want you to say a word unless you know it is 100% accurate, unless you know it's 100% true. Do not say a word. And you may be saying right now, hold up, Professor Kupenda, hold up. If I can't speak unless it's 100% true, I'm not going to be talking very much. In other words, if I had a rule like that, would it chill your speech? You got it now, don't you? Would it chill your speech? And so all of these questions that I'm throwing out here, and I know you think I'm playing, I am, but only to a degree. all of these questions are related to the concept of defamation. So what is defamation? So defamation is the publication or communication of false statements, right, that cause injury. I mean, that's putting it very simply. If you look for my students who've had torts, they probably have a more detailed definition of it, or you may look on Google and you may find a more detailed information. Defamation is primarily governed by state law, 1st and 14th, if you're arguing about the defamation, right? So with defamation, usually you're going to have a state law that says if you do this, if you tell a lie on a person, publish it, and cause harm to their reputation, they can sue you. But then in the cases we're going to examine, you're going to have a speaker who replies, oh no, what I said may not have been completely true, but I had a First Amendment right to say it. And so we're going to examine how the court deals with those situations. Now, I will tell you that defamation is in an unprotected category of speech. Defamation. Now, how the court deals with this is really fascinating. The court says, of course, the First Amendment does not protect an outright lie, a lie. However, the court says that sometimes when we engage in robust debate, like if, let's say here we are, and here's the truth. Sometimes engaged in robust debate, we're not always completely telling the truth. We may cross the line into a lie as we engage in robust, uninhibited debate. But while the First Amendment does not expressly protect lies or encourage lies, the court said sometimes lies may become unavoidable. So when we get to defamation, you're going to see how the court parses it out and whose reputation is the court concerned about more. For now, I just want you to think on those things. You know, should the First Amendment protect lies? What happens when reputations are harmed by misrepresentations, misstatements, right? And what if you had to tell nothing but the truth and the whole truth until we meet again next week? Would it chill your speech? Now, I know you're saying, what's up with you, Professor Kupenda? More questions than answers, of course. Thinking on these questions is a key to learning, and learning is a key to enlightenment. And enlightenment puts us well on our path to justice, or at least a taste of justice. I'll see you later. I'll see you again next week as we talk about defamation and then obscenity. Okay, bye. You take care.